We're here on an emergency temporary restraining order in the Fisher case. Mr. Godwin, if you can announce the case name and cause number.
Yes, Your Honor. This is Don Godwin here, and the case name is Gail Corder Fisher versus Cliff Fisher, Ted Uzelak, Larry Teal, Judd Thomas Smith and Company, and in turn, Clifford Fisher and Company versus Gail Corder Fisher. And the cause number, Your Honor, is number DC 19-17340.
All right. So there was an emergency temporary restraining order filed yesterday. We were in the middle of trial. I understand that there's a meeting on Wednesday, a compensation committee meeting Wednesday, as I understand it. And Mr. Godwin,
that's not accurate, Your Honor.
I'm
There's
sorry.
a board of directors meeting scheduled for Wednesday.
Okay.
On the agenda is whether or not to convene a compensation committee. That's why this application is premature. There's no
Okay.
immediacy.
Not at all, Your Honor. I mean, here, it's going to be my opportunity to present first, and Larry's already trying to take charge of the meeting.
I'm not trying to take charge. I just wanted to point out that the affidavit is effective and the documents haven't been authenticated, and therefore the application in its entirety should be denied.
But that's ridiculous on its face, Your Honor. You can see from the application that one of the first exhibits is Exhibit A, a letter from Larry Freeman to me. I can authenticate that with all the attachments attached to it, but I want to go through my application, Your Honor.
Why don't you share screen the application? I'll go ahead and enable that.
Okay.
Go ahead.
We're going to try to get that done, Judge. Can somebody do that? I've got someone trying to share screen that, Judge.
Anybody can. I've enabled it.
Thank you, Your Honor.
Who's doing it?
Kristen Burns from my office is attempting to do it, Your Honor, as we speak. They're trying to pull it up.
Let me see if I can find it. Okay, so give me the cause number again. It's DC what?
DC 19-17340, Your Honor.
Okay, let's see if I can pull that up.
Can anybody share screen that for the judge?
Okay, Mr. Godwin's time is up. Should I go, Your Honor?
Are they share screening the document yet?
We're trying here, Your Honor.
So I see the motion to appoint receiver.
That's
Here's
going
the
to be heard on August 16, Judge.
Okay. All right, let me share screen this.
There are two motions to appoint receiver. One is the company's motion that was first filed, and then Mr. Godwin's motion, which was second filed.
Okay.
Judge, we now have here Gail Fisher's application for temporary restraining order against Clifford Fisher.
Okay, I tried to share screen and it's hard to read. Do you want to try to share screen it?
Well, I think we have it up here, Judge.
No, I just pulled that up, not y'all.
Oh, I'm sorry. Excuse me, Judge.
But my version it's pretty hard to read. So
Well, it was small.
there you go. All right,
There
that's
you
much
go.
better.
Now we have one up here. This is better. Is it you, Kristen? Kristen's.
She did it.
Okay. Thank you, Judge.
Thank you. All right, go ahead and make your argument, Mr. Godwin.
Thank you, Judge. Your Honor, first, let me say that yes, this is an emergency situation. And I do appreciate your willingness to hear it on such short notice. It is certainly appreciated by me and my client, Gail Fisher. Your Honor, Gail Fisher and Cliff have been 50-50 owners, as you know, from having looked at all the motions for summary judgment, which were denied. You know that they've been owners of the company since 2008. At the conclusion of their divorce, Your Honor, the family court ordered the company be sold at the insistence of Cliff Fisher. This was affirmed by the Dallas Court of Appeals on March 4, 2021, and both Cliff and Gail have signed the engagement agreement by Cowan and Company, the company designated to sell it, to serve as a broker over the state. Cliff Fisher is now refusing to sell the company, Your Honor. We filed a motion for contempt for his violating the court order regarding that be done. In 2017, Your Honor, while Cliff and Gail were married, Gail's compensation was approximately $3 million, not including shareholder distributions that were to be made equally between herself and Cliff Fisher under subchapter S of the Internal Revenue Code. And in fact, Judge, in 2014 to 2017, Gail's average compensation totaled almost $2.6 million, not including the Internal Revenue Service determined distributions that were made from profits. In 2018, Your Honor, after Gail filed for divorce, after many years of abuse by Cliff Fisher, Cliff whittled Gail's compensation down to about $120,000 a year, $120,000 a year. Since then, Your Honor, Cliff Fisher has unilaterally declared and stated, and his lawyers have stated on his behalf, that unless and until Gail settles this lawsuit, there will be no shareholder distributions. That's where she was making most of her money. He has withheld that money. The only money that's been paid to her this year as a distribution was for a tax distribution that they got the exact same amount for their 2020 taxes. As a result, Your Honor, Gail's compensation has been dwindled to minimal commissions, less than $100,000 a year, while Cliff continues.
Can I ask a question here? And this is directed to both you and Mr. Friedman.
Yes, Your Honor.
And I feel like that sometimes I'm kept a little bit in the dark here by both sides. So I feel like that right now is obviously this company. I don't know how this company could possibly. They're both 50% owners, right?
Right, Judge.
How this company can function. What either we need to appoint a receiver, let the receiver deal with all this stuff, including compensation committee decisions, or we need to let the company just do what it's going to do, and you guys need to agree. But I don't see that I should be jumping in the middle of each decision on what's going to happen within the company and try to decide, based on my limited knowledge on what you guys present, that what the company should be doing. Either there needs to be a receiver or the company just needs to function on its own. But you guys have delayed the hearings, and this is what I don't understand. And I'm not criticizing anyone. I just feel like there's something there's something going on that I don't quite know about or understand or not getting or whatever, that you guys have delayed the appointment of a receiver hearing until one was on August 16th and the other one was set like in December.
Well, let me address that, Judge, if I might.
Well, wait a minute.
Let me address, Larry, I'm the plaintiff here. Let me address
But he addressed this to both of us.
Well,
Judge,
he said both of us, and I asked to be allowed to speak.
Wait. I decide, Mr. Godwin, go first. Mr.
All I'm
Friedman
asking
or
for
Mr.
is
Roberts.
equal time.
Your Honor, August 16 was the first date that we could receive from your court coordinator for the hearing on Gail Fisher's motion to appoint a receiver.
But before you guys asked for December or something, which was
no, Judge. What happened is the company has
May I
filed
finish,
three.
Judge? Your Honor,
The company has filed three
Just one second.
receipt.
Judge, you asked me to respond, and I'm trying to do that.
okay. Well, Mr. Godwin, let me just say this. who was it that wanted the receivership motion to be held in December? Was that Mr. Godwin or Mr. Friedman or Mr.
Well,
Roberts?
Judge, nobody wanted it to be heard in December. The problem is the receivership motion was filed with 2 other enforcement pleadings. And because there are 3 pleadings, we were told that the only time available would be, in December to hear them all. So that's why they're set so far out. We have a contempt motion, a receivership motion, and a court of inquiry motion.
Mr. Robert, and that's what I don't understand, Mr. Roberts, is why are those 3 things? And this is what I think I might, and I'll direct this to Mr. Roberts. Why do those things have to be heard together? Why can't we just do I don't see how this company can be run right now.
Let me address it, Seymour. Let me address
Okay.
All right, Mr. Freeman.
All right. Your Honor, if I can clarify this. Gail Fisher stole $5 million from the company. It was an unauthorized money grab. The company filed a motion for receivership over that $5 million because we have not been able to get it back. So we've asked for a receiver to oversee the $5 million that she took and everything she did with the proceeds. So for example, she spent $2 million on a new house for herself. We think that that's encompassed with the company's money and there should be a receiver appointed over that money.
So Mr. Friedman, are you opposed to having a receiver appointed over the entire company?
Oh,
You just wanted
absolutely. This is a huge company. There are hundreds of employees. It's an international company. It's a very successful company. And Mrs. Fisher has been getting her salary or her compensation the same as she always has. It's been tied into her commissions. And when she started to complain about the distributions being improper, the company stopped making distributions to anybody, not only Mrs. Fisher, but also to Mr. Fisher, until the court makes a ruling as to what is proper distribution. So the point is, you can't have it both ways. You can't say the distributions to date have been improper, but now make the distributions because she wants money. So it's either or. Either she has to withdraw her complaint about the prior distributions, or she has to withdraw this complaint about giving the company an opportunity. Well, just finished, giving the company an opportunity to have the court hear the dispute and decide the propriety of these distributions.
Let me ask this, Mr. Friedman, and then Mr. Godwin, you can respond to this point.
Thank you.
Is this a company that's owned 50-50 by Mr. and Mr. Fisher? And if there's a tie between the 2 of them, how is that tie broken?
Because they're not the only 2 on the board of directors. They have a very distinguished, they have a very distinguished 5-member independent board of directors.
Board of directors can't decide ownership issues, Your Honor.
And we're
The
not
ownership,
asking
the
for that.
shareholders decide who the directors are. They oversee the officers of the company. The ultimate decisions regarding the decisions should be made by the owners 50-50. Cliff Fisher is not allowing Gail to make decisions. And so
that's not the case, because
we've got a motion for the appointment of a receiver to be heard on the 16th. If this matter does not need to be heard today, if they were to pull down their board of directors meeting for next Wednesday, Judge, where they're going to try to get a comp committee appointed to decide.
I get that. I'm just trying to I'm trying to figure out what's going on. And so let me ask Mr. Friedman and Mr. Godwin and get a chance to respond. So let me make sure I understand how this company is structured. So there's 2 owners, correct?
basically 2 owners, but some key executives that have a profits participation if the company is ever sold. But yes, there are 2 equal owners.
2 owners. And then how are the board of directors selected?
The board of directors are selected independently. And when the slate was introduced earlier this year, I want to say within the last 90 days, Mrs. Fisher voted unanimously to continue the next term of the same board of directors. She had an opportunity to object to these people, but didn't.
Okay, that answers my question then.
These
That's
people-
that was the disconnect in all this that I didn't quite understand. So these 5 board of directors were unanimously approved by both owners?
Yes, yes, sir. And there can be no tie because it's an odd member board of directors. And the meeting on Wednesday is a board of directors meeting. John Palter is the corporate counsel. He put on the agenda that the necessity or the desire for a compensation committee to be appointed is one agenda item. So she can vote for it. She can vote against it. The other directors may vote against it, but it's worthy. It's to be a topic of conversation at the board of directors.
Judge, may I go?
Okay, now I get it. I understand more what's going on. Okay, Mr. Godwin, you can proceed.
Yeah, and at this board of directors meeting, they're going to appoint a compensation committee. And they're not going to be cutting Cliff Fisher's income, Larry Teal's income, or Ted Uselak's income. They're going to be trying to cut Gail Fisher's income from the paltry $120,000 a year she makes now, compared to the $8 to $10 million a year.
Mr. Godwin, can I ask a question then? If she's so concerned about the board of directors, why did she agree to these 5 directors? Because if I understand this correctly, and maybe I'm not, is that there's 2 people voting. They both have to agree on who's on the board, and she agreed to this board. Is that true or not?
Yeah, she did agree to the board members, Your Honor, no doubt about that. But that doesn't mean she's agreeing with every board decision. And the only time I've ever come to you about an issue involving this company is today, involving this decision to take her income away. Cliff Fisher wants to set up this compensation committee to completely derail any income she gets. Just a minute.
Who are the 5 board members?
Yeah, and so, Judge, as you can see, the 5 board members are Cliff Fisher, Gail Fisher, and 3 other folks. And there are 5 of them. What we've asked for in our receivership motion is to dismantle the board, take Cliff Fisher out as the CEO, and appoint a receiver to run the company, because they are at a deadlock. They cannot agree. The 2 of them can't agree. The law is very clear in Texas. You can't make somebody own a company with somebody else when there's a deadlock. You have to have a receiver come in to be able to decide issues when there's a deadlock. If they owned it disproportionately, it'd be different, but they own it 50-50, Your Honor. And in the absence of an agreement, some third party has to be there. The issue on Thursday is it's in my judgment, it's a railroad job by the board and Cliff to be able to come in, take her income away. And as Cliff has said, I'm never going to give you any more distributions out of the company, although he's taken $8 to $10 million a year out. As a 50-50 owner, she's getting $100,000. He said, until you settle with me, I'm not going to give you any more money.
Can I ask a question here? Is there a procedure within the corporate bylaws or anything like that? So right now, the board that's currently constituted, there were 5 members that were agreed to by both owners. If one of the owners withdraws their consent to that, does that have to be done at an annual board meeting, or how is that done exactly if there's no longer consent to who's on the board?
Well, if you have the members of the board, Your Honor, the board members are going to continue year after year unless there's a majority that votes them out. And Gail's the only one. There's 2 shareholders that decide the board members. See, that's the way the board is actually 5 people, but it is decided by the shareholders who will be on that board. In the absence of an agreement, then you have a deadlock on who the board members are going to be.
Does it take a majority to remove the board, or does it take a majority to renew the board?
Can I address that, Your Honor?
Okay, Mr. Friedman.
So a couple of things that needs to be clarified. Number one, Mrs. Fisher unanimously approved the members of this board. Number two, Mrs. Fisher also approved the budget for the year, which had the executive's compensation in the budget. Number three, her salary has not been changed. It's been the same salary that she's got since the company started. It's just that when she complained about the distributions that were being made, the board of directors decided not to make any more distributions until the court decided whether or not further distributions are proper. But up until that time, up until the time she stole the $5 million from the company, she was receiving 50-50 distributions.
Judge, and in terms of the $5 million, Cliff Fisher has taken that same amount of money out of the company. And Larry Friedman's own letter says there now is no balance owed by Gail Fisher. Everything has been trued up. But let me say, Larry just said that the board decides, Your Honor, the board decides on issues that relate to ownership matters. And he said that the board is the one decides that. No, the board doesn't decide who is going to be on the board. The owners decide it. And the owners have two people. They have the board. And my position is this. Judge, for 30 years, this company's been in existence. Larry said it's an international company. It does about 50 million a year, which is a lot of money, but not a huge company by any means. It does not have hundreds of employees, Your Honor. Having said that, for 30 years, they've operated without a compensation committee. Now, once we come in here with 5 new lawyers that have been added from the Shields law firm, all of a sudden we got this new idea that Larry Friedman has never come up with. In a year and a half, we've been fighting and talking about having this new compensation committee. Now they have this compensation committee idea, and it's clear on its face that the purpose of it is to take away what remaining small amount of money my client is getting. She is not allowed to have any say over the management of the company at all, Your Honor. She's a 50-50.
But she doesn't she have a say because she gets to choose the members of the board of directors?
No, Your Honor, she doesn't. For the reason, that's where you're missing this, if I might respectfully. In the event, 5 years ago, the board was put in place. Gail Fisher voted the board in along with Cliff Fisher. Since then, Your Honor, it's always been in the absence of an agreement. They always continue with the same board. And even if she voted to put these board members in place, that doesn't mean that they ought to be allowed to come in here with a new compensation committee and take away her income. I mean, we got a lady here, Judge, that's being bullied. The company is paying Cliff Fisher's legal fees. She's having to pay her own out of her pocket. And there's millions of dollars being spent by him and by her. He's having his paid by the company, of which he owns half of it. All I'm asking you for, Judge, is a temporary restraining order to say they can have their meeting next Wednesday. Have your board of directors meeting, but don't take up the subject of a compensation committee until we have the receiver hearing on August 16th. There's no harm that could be caused to Cliff Fisher by that, but there's tremendous harm that could be caused to my client. She's going to lose her remaining bit of income, and it's going to be no harm to him. All I'm asking you for here today, Judge, is that that Cliff Fisher be prohibited from going forward with a board meeting next week that would include the compensation. Have the board meeting on all of the subject, but not that one subject. On August the 16th, when you hear the receiver, then at that point, and if they want to have their receivership motion heard on the same day as mine on August 16th, let's do them both. And at that motion, then you can decide, Your Honor, whether or not there's going to be a receiver in place to take charge of this company, because they can't, Cliff Fisher and Gail make the ultimate decisions. And if they can't reach agreements, then there's got to be somebody that's got to break the tie. That's the purpose of a receiver, as you well know. That's what I'm after, Judge. I'm not here today after money. I'm not here today to say anything about the receiver other than what I've already argued. I'm here today to say, have your meeting next Wednesday, but you will not elect a compensation committee then until we have a hearing on August 16th. In a couple of weeks, if we get the restraining order in place, injunction hearing comes up, we try to reach an agreement, or Your Honor can extend it. You can extend it. We try to extend it till we get to August 16th. And then you can hear it all with evidence. And then you can decide, Judge. That's what I'm asking you for. Nothing more, nothing less.
Let me mention just a few things, Your Honor. Number one, don't feel too bad about poor old Mrs. Fisher, who received already about $50 million in the division of the community estate in her divorce. So she's going to make it between now and the end of this proceeding.
Judge, could we be a little bit more respectful about poor old Mrs. Fisher and all that? I mean, you know, we really don't need to go to that level, Larry.
It's all right. It's okay, guys. It's okay.
Okay.
Mr. Friedman.
Number two, we have two receivership hearings coming up. One of them, Mr. Godwin is attempting to have a receiver appointed over the entire company. This mechanism that the board is proposing would have a 3-member committee, 3 members, the independent board members would be on the compensation committee, and they're going to hire an expert that's familiar with the field to come in, do a study, and determine whether Mrs. Fisher, Mr. Fisher, and all the other senior executives in the company are being paid or overpaid. And that's information we need to present to you at these receivership hearings. So we shouldn't be blocked from being able to do the job the company has a fiduciary duty.
Mr. Friedman, let me ask you a question, because this might short circuit all this. How would your client feel about if we put a TRO in place that we could have this committee set up and they could meet, but there would be no action taken until after the receivership motion is heard?
Well, no action taken until further order of the court, that the distributions and salaries stay the same until further order of the court.
That seems pretty fair, Mr. Godwin.
Well, I want to be able to further order the court. What I want to do is have a hearing on my receivership motion. So when they say further order of the court.
Well, as long as I'm the judge of the 68, then I'm not going to do this until the receivership motion. I agree with you. I don't want these distributions to change until we hear the receivership motion. And I would strongly recommend that we hear all these receivership motions together, because I don't think it makes any sense for me to have 2 separate reciversats.
Well, I'm fine with that,
How many
Judge.
days are left for your term, Your Honor?
Well, hopefully it's going to be a while, but at least until the end of 2022. So
I'm just trying to pace myself.
Mr. Friedman, how do you feel about that?
I mean, I think that would be acceptable. If you give me a minute, let me try to find my client and make sure it's acceptable to him, but it sounds reasonable.
Mr. Godwin, what do you think?
Well, I don't think there ought to be a committee put in place until August 16. There's no harm done to Mr. Fisher by doing it.
But
no harm done, but there would be harm to my client by just having the committee there, because that would be the first step toward giving Cliff Fisher what he wants. So I suggest to you, Your Honor, and I ask you to say,
Mr. Godwin, sometimes you got to compromise.
I understand that, Judge. And
I'm trying to give your client what she needs, maybe not what she wants, but what she needs.
The other thing is,
well, if I might address that, Judge, with all due respect, I feel like I've been doing some compromising in this hearing that I don't know that I ought to have to be doing. But having said that,
why don't you each talk to your clients? Just put me on mute, see if that's okay with them. What we would do is put a TRO in place that until further order of the court, there would be no changes to the I guess, I don't know how you put it, Mr. Friedman, but the distributions or compensation until further order of the court. You could put either, or if you're both okay with it, or until the receivership motion's heard. I don't mind you putting in that either. But I really feel very uncomfortable jumping until there's a receiver in place, jumping in the middle of these types of decisions, whether or not committees are formed within this company. That's really the role of receiver, not mine. So
can we have a minute to talk to the clients?
You guys will each have a minute. All right. So I'm going to give you, I'm going to put myself on mute, and you guys can put yourself on mute and talk to your clients.
Thank you, Your Honor. Yeah, I'm fine having them both heard. Because the more of this he can hear, I'm fine. The more he can hear, the more he's going to understand how she's been put upon.
Okay. I'm ready.
All right,
to
has
adjourn.
everyone had a chance to talk to their clients?
I have, Your Honor.
Yes, sir. So,
Let me go.
Mr.
Let's let Mr.
Fisher,
Godwin go first.
Okay, Judge. I've spoken to my client, Your Honor, and her position is that while we don't think any committee ought to be formed, we certainly defer to Your Honor and respect your judgment, but without reservation. That said, Your Honor, we would be willing to go along with, I say not willing to go along with, we would appreciate the entry of a temporary restraining order that would allow a committee to be set up or prohibit the committee from taking any action with regard to Cliff Fisher's income, Gail Fisher's income, or any other officer of the company pending, and that is income, distribution, salaries, whatever form of compensation. It
I
cannot
mean,
go
any
up or
type
down.
of change, any type of
Any
change.
change, exactly, Judge, exactly. And no change at all for anybody's income until there's a receiver hearing, and it's presently set for August 16, with the understanding, I explained to her that Mr. Freeman's, on behalf of Cliff Fisher and the company, their motion for the appointment of receiver could well be heard on that same day. She said, that's fine. She's ready to have it heard. So again, we would appreciate the entry of a TRO today that would prohibit any change in anyone's income at the officer level at the company until there's a receiver hearing, Judge.
Mr. Friedman, how do you feel about that?
yeah, my client's amenable to it, but it's a little bit different. No change in anyone's compensation until it's heard by the court. And I would ask the court to give us time to hear both receivership motions at the same time. I think Mr. Godwin's receivership motion was scheduled for, I don't know, an hour and a half or 2 hours. I think we need a full day to hear both.
1 hour. Except for 1 hour, Judge, not an hour and a half.
It's not going to, it won't be completed in 1 hour. So maybe you can find.
Mr. Friedman, let me tell you what I can do, because this morning I had 20, how many was it? 27 pretrial hearings. I have 4 days of trial settings next week where I'm calling down 3 trials on Monday, 3 trials on Tuesday, 3 trials on Wednesday, 4 trials on Thursday. COVID is coming. This is exactly what I was worried about. This is why I've been wanting an associate judge appointed, but we don't have one yet. We are absolutely slammed. And so I'll hear your receivership motion. I'll hear both receivership motions. I just don't have time. I'm going to be in jury trials from now until the end of time, I feel like. That being said, I'll set them both
Better
the same
pace
day.
yourself.
I know that's exactly what my bailiff said today. He's like, Judge, you got to pace yourself. But I mean, we're just so far behind. And so
here's the thing. I'm gone. My nephew's getting married. I'm on the East Coast for most of August. I just asked that you find a day.
Judge, how can you be going to a wedding for a month? I mean, listen, that's ridiculous.
Yeah, we're on the East Coast. We're on a wedding for 10 days, and then we're taking a few weeks off. So somewhere in September would be, or beyond would be good for us.
Judge, they just want to delay it. They've just hired, Cliff Fisher just hired 5 more lawyers. Larry, and when the lawyer, Jim Shields, sent his notice of appearance recently, he said he was going to be the lead lawyer, the lawyer in charge. It was after I called Larry and talked to him about it, and Larry got involved in it. Then Mr. Shields sends back and says, well, they're just going to be joining as co-counsel. So the point being is Jim Shields intended to be the lead lawyer. He said,
no, Your Honor, that's a mistake. That's not
No,
true. I filed that motion and it was my mistake. I take full responsibility for that.
But having said that, Judge, they now have the fine lawyers in Freeman Feiger, Alan Lowensen's firm. They got 3 or 4 different law firms. Now they got a Shields law firm. All these are being paid for by the company with money that is half my client's money, while she's having to pay her own legal fees. Now, I do have before you a motion for indemnification where we're going to be seeking all of our legal fees paid back for all the time she's had to pay her own. But while you're allowing them to do these things and they're going to want to delay, they're paying for.
I haven't allowed them to. I haven't allowed anything.
Your Honor, I'd ask that you
Wait a
take.
minute, they're paying
I'd
for all
ask
of
that
that
you
out of
take
the company,
additional
Judge,
notice.
that my
Wait.
client owns half of. If they start paying
Yes.
her legal fees out of the company, 50-50, the same to me, same to Larry, then we'd have no problem with that.
I'd ask that you take judicial notice that no matter how many lawyers the company hires, they're no match for Mr. Godwin.
You know, and while I do appreciate that, Your Honor, I do appreciate that. You know, it reminds me of one time years ago, I was in a divorce case with Bill Coons, the famous Bill Coons. And when it did, we were challenging legal fees. I was here challenging his as a kind of a new lawyer, like a fool. And Bill was there, and in the divorce, Ned Stewart was presiding. And when he did, I challenged the fees, and his rate was then like maybe $3.50 an hour, something ridiculously low, but it was back then. And I said, that's got to be unreasonable. And Bill Coons, as smart as he was, he turned and he said, well, he said, it probably would be unreasonable for you, Mr. Godwin. But he said, you know, if you practice long enough, there's a hope you might get there, but I doubt it. And we laughed about it. And we laughed about it in the hall afterwards. But Bill was a great guy. But the point is, Larry's giving me a compliment, and I appreciate it. But I can tell you,
I've kind of lost point of what we've been arguing about at this point. So.
Well, I can tell you what we were arguing about. It's like me being at the Alamo and I'm Jim Bowie, and you've got 10,000 Mexicans coming at me, and Larry complaining, well, you got Jim Bowie and Houston there. Why would you need any more? Here, I've got up against Larry Friedman and all these other great lawyers. And while he says I do a good job, I do try. And you know that, Your Honor.
I do. You guys are both doing a great job. So the main issue right now is, so we've agreed to the TRO. I need a form of the TRO to be submitted to me that complies with what the order is. So, Mr. Godwin, if you could put that together and share it with Mr. Shields and Mr. Friedman.
And I'd like to have this heard in August, Judge. We've got to.
Yeah, and I haven't said that I'm going to move it. I mean, I want to try to work with Mr. Friedman's schedule, but I agree with you. I'm not going to just move it indefinitely. And I do feel like we should do both receivership motions. This interesting court of inquiry thing that Mr. Roberts came up with is going to take some time. I just don't have time to hear that.
Well, Judge, we can leave the contempt and the court of inquiry we can leave that in December, and
Yeah.
we can move up the receivership motion to the date that we hear Mr. Godwin's motion.
And I'm fine with that, Judge. I'm fine with that.
That sounds good then. So the question is, Mr. Friedman, right now we're set for August 16th. You gotta,
I'm not going to be in the country. My nephew has a wedding in Philadelphia. We'll be there for 10 days.
So we'll move it a little bit. So
he's marrying an Indian woman.
Oh,
So
great.
the celebration is 10 days. And then right after that, my wife and I are going on our benchmark anniversary trip that was postponed from last year. So please bear with me as I take 2 weeks to take my wife somewhere exotic.
Pick a Monday between, Mr. Friedman, I want to work with you, but I got to also consider both sides.
I'm
Pick a
pacing
Monday
myself.
between August 9th,
Judge,
August
what about all
30th.
these new lawyers that Mr. Friedman calls me about, and he says that they now have Jim Shields that they're going to have.
I think it's Brian Shields. Is it a Brian Shields or is it?
Yes, Your Honor. Right now it's Brian
Judge,
Shields.
Mr. Jim Shields is Larry's co-counsel, was designated as lead. Jim's in the case. He's just not here today. He's on
Okay, sorry.
He's in a boat in the Caribbean, as I understand it from Larry. So
You guys
Your
have a
Honor,
great life,
Mr.
it sounds like, all these scripts.
Mr. Godwin and I will choose a date.
I'm just saying,
I want to choose a date that's in August. I'm not interested
What I'm saying, guys, okay, this is what it's going to be. I'm going to let Mr. Friedman choose because he has this stuff going on. You pick a Monday in August, Mr. Friedman, that is the best date for you, and then we'll set it that day. So
All right,
which Monday in August do you want to use?
I won't be back till the 2nd of September, so make it the first Monday in September.
That's Labor Day.
We'll make it the second Monday.
That's not in August.
Well, on the Hebrew calendar, it's August.
I'm really,
Mr. Friedman, I really tried to work with you here. Can you not do a date in August?
No, I can't. I mean, I've got prepaid tickets and plans and, it's all booked and everything. And I'm going to let Mr. Godwin tell my wife that he's going to ruin her anniversary trip because I'm not telling her.
I love your wife, you know that, but
Your Honor, with the TRO in place, there's no reason it shouldn't be pushed to September.
You know what, Mr. Shields, that was probably the smartest thing that's been said today.
Thank you, Your
That's a
Honor.
very good point. Mr. Friedman, are you sure that's in your client's best interest? Because that means there's not going to be any change to the compensation until.
He's good with it. He's good with it.
That's kind of a win.
the difference is, Judge, no, I disagree with that. And with
Okay.
what Brian said, with a TRO in place, that has nothing to do with the receivership. I want a receivership appointed to take over operations of the entire company. That has nothing to do, Brian, with the income. I understand a TRO on not affecting income, but I want a receivership motion heard so we can have this company taken over and run for the best interest of both, not one. Currently, Your Honor, it's being run for the best interest of Cliff Fisher, who's acting like he owns 100% of it. And
Well, I mean, that's a lot of one-sided argument with no evidence.
Mr.
Okay.
God-
Seymour, I just assumed, you let me and Larry argue it. And of course, I can definitely respond to that if you like.
You're a little outnumbered here, Mr. Godwin. Maybe Miss Scott, Miss Dean, and Miss Valderrama can help you out here. So
I think we're doing all right, Judge.
Your Honor, it seems like September 13th would be fair for everybody with the TRO in place.
I disagree with that, Judge. The TRO has nothing to do with the receivership. I want the receivership heard in August. And if Larry can't hear it, Jim Shields can hear it, or Brian Shields can hear it, or better yet, Seymour. Better yet, Seymour. So the point being is, Judge, we've had our hearing on the books in August on a receivership motion. They now come in with 5 new lawyers and Larry telling us about being gone for a week. And all of a sudden, there's a chance my receivership motion is going to get pushed off.
But
That
Judge,
doesn't seem
first of
right
all,
to
we need at least a full day. And second of all, there's no prejudice to just move it a couple of weeks.
I mean, you're moving it a month though with that. That's the thing.
There's no prejudice. There's going to be no change to the
Sure
way
there
they've been
is.
doing business and paying compensation for the last 20 years.
Judge, there is for this reason. If a receiver takes over, he may decide to cut Cliff Fisher's income, and he may decide that Gail Fisher's legal fees are going to be paid by the company just as Cliff Fisher. So yes, there's prejudice. That receiver is going to have wide, broad authority by you under your supervision to do what he or she believes is necessary.
The company is eminently successful, as every one of these board of directors will tell you. This is just a ploy to bring Mr. Fisher to the table. I understand it. I respect it. I just don't want it to ruin my anniversary trip.
And Larry,
On September 13th, the receiver can
Larry,
still
when you
give
say
attorney's
that
fees.
about a ploy to bring them to the table, you want me to really start divulging our confidential settlement discussions you and I've had, which I said I wouldn't do. So don't start trying to bait me with it, please. I haven't done you that way and asked you not to do it to me. You and I've been talking, trying to get things worked out, and your client won't come to the table, and you know it. Judge, I'm tired.
I can say the
Whoa,
same.
wait. Okay. This is the end of the discussion. No more argument. This is what I'm going to do. I'm going to order you guys back to mediation. We're going to set this on September 13th. I'll give you 3 hours. That'll give you time to be able to clear my schedule. Both receivership motions are going to be set, and we're going to enter the TRO as discussed, as instructed. And Mr. Friedman, you're going to need to figure out a time when you can do this mediation between now and September 13th.
I'll do it, Judge. Thank you.
Yes, Your Honor.
All right, guys, good luck. And Mr. Friedman, other thing I was going to mention is I've been thinking about the receivership issue. I'm thinking of 3 different people potentially as receivers if I appoint one. Are you guys thinking we'd have 1 or 2 receivers? I think you just have 1, right?
One, Your Honor.
The last time I was thinking about it, there will be none. There's no basis for receivership.
Okay, if
But I
there is
respect
a
your
receiver,
opinion.
if there is a receiver, well, you want a receiver too. You want a receiver over.
No, we only want a receiver over the money that Mrs.
No, that's what I'm saying. But you want a receiver that direction. But we wouldn't need to have 2 different receivers if I agreed with both of them.
Correct.
Judge, when you hear their matter,
Okay. No. We're not arguing that. So these are the 3 people I'm thinking of. And so unless something changes, I'll probably give you these 3 so you can kind of do some research about them. And you'll each get to veto 1 if I appoint a receiver at all. But so you might want to write this down. So one of them will be Royce West. Second would be Kevin Buchanan. And third would be Trey Black. All right. So those are the 3 possible receivers. And then you guys would each veto 1 if they end up getting appointed. So I just want you to kind of be thinking about that. All right, guys, anything else today?
Judge, when you say you're ordering us back to mediation, do you mean mediation before the 13th?
What he said.
Yes.
and
Who's your mediator? Is it
Mark
Chris?
Whittington.
Judge, which mediator?
Oh, I don't know. I thought you already had a mediation. Haven't you been to mediation already?
Yes.
Well,
You
we
wanna
had
use the
one,
same
didn't
Who
work.
do you want? I'm going to let Mr. Godwin, you pick 3 mediators, and it can be either we're going to use, Mr. Godwin, we're going to use the same mediator, or you pick 3 mediators and Mr. Friedman will get to pick out of those 3.
Well,
What do you-
Mr. Larry and I'll work it out. Larry and I will agree on a mediator, Your Honor.
Yeah, we'll work it out.
We can work
Okay.
that out between us.
No problem.
Thank you,
But
Your
you
Honor.
need to,
Your
you need
Honor.
to mediate. I want to make it clear, you need to mediate before September 13th.
We
Yes,
will,
Your Honor.
Judge.
Your Honor, Reed Loftus here on behalf of Judd Thomas Smith and Company.
Mhm.
We've only been in this case a couple months. I'm not sure we're ready to go to mediation with Ms. Fisher. Are we in this order as well, or?
You are.
Okay, thank you, Your Honor.
Everybody needs to go.
Thank you, Judge.
All right, so get me an order on all this. You guys have a great weekend. And I just want to remind you, email the order to Rhonda. Make sure the order says on it that we heard this on July 16th, 2021. And I'll get it signed on Monday, okay?
Good.
Thank you,
Thank you.
Judge.
Thank you, Your Honor.
Have it to you.
You guys have a great weekend. Good to see you.